Good evening, everyone. This is Greg Giardino with J.M. Franklin and Company. We're glad you could join us. Tonight's topic is all about estate planning, specifically the 5 estate planning pitfalls that you need to avoid for 2022. So we'll be discussing some of the basics, why it's so important to have an estate plan, what are some of the issues if you don't have one, LegalZoom, what are some of the different types of trusts, what and when do you need them, as well as how you should be thinking about long-term care planning in the context of your estate plan. And make sure you stay until the end, where we'll have a live Q&A session so you can make sure that you get all of your estate planning questions answered. So quick disclaimer, neither Ryan Brodlin nor Brodlin Law are affiliated with J.M. Franklin and Company, LPL Financial, and Stratos Wealth Partners. The information provided tonight is for general purposes only. If you're looking for specific advice, please consult with your tax, legal, or financial advisor. So our speaker tonight, Ryan Brodlin, who's with us now, he's the owner of Ryan Brodlin Law, LLC. He's admitted to practice in both New Jersey and New York, and his specialty revolves around wealth preservation and transfer strategies, specifically retirees, and working with them to transfer their wealth in the most efficient manner to their loved ones. With that being said, I'd like to introduce to you Ryan Brodlin.
Hey, thank you so much, Greg. I appreciate the kind introduction. I appreciate you inviting me to be part of this, and thank you to everyone who is here for your time. As Greg said, my name is Ryan Brodlin. I am an estate planning and elder law attorney practicing out of Morristown, New Jersey, but also practicing in New York as well. I'm going to jump into things pretty quickly. I don't want to take too much of everyone's time on this beautiful evening. But quickly, a few housekeeping items. I'll start my slides in a second. When I do, you're going to see my contact information. As Greg mentioned, we'll have a chance for questions and answers at the end. Type them in the chat box, whatever you'd like. I'm going to let Greg be the moderator of that. And if there's anything more detailed or personal that you want to go over, please take my contact information down. You'll have my email, you'll have my phone number, my website. You'll see the spelling of my name, but it's brodlinlaw.com. All of those ways you can schedule time to speak with me on a complimentary basis to go over your personal situation, and we can talk and see if you need to do anything, if you're already set, and you make a good recommendation for you if necessary. I'm going to start my slides. You ready for that, Greg?
We're all set.
Okay, let's see. So I'm going to share my screen, and we will start the slideshow. All right, so as I mentioned, we're going to go through, here's my contact information. If you need it, Greg will have it as well. We can circulate it as need be. That's my personal number. You get me directly from that. So if you want to talk again, please give me a call. We're going to talk about 5 things today. We're going to do a high-level overview of these 5 things. We're not going to get into the nitty-gritty because I would be then taking up hours and hours of your evening, possibly on each of the 5 topics alone. So hopefully you get some either alarm bells ringing from things you're hearing, or think about things from your specific situation that might be relevant, and it cues you to maybe take some action, or to think, nope, you've already done that and you're all set, which is great. My favorite thing is when clients call and they don't have anything to do because they already are in a good position. I love delivering that news. So we're going to talk about these pitfalls, why you should not assume you do not need an estate plan, what happens if you fail to update your estate plan, the pitfalls of using LegalZoom, using trusts when appropriate, and finally not considering long-term care needs in your estate plan. Jumping right in, this is the first topic is why have an estate plan at all. And Greg, is this something you hear about a lot when you talk to your clients?
Yes, in fact, I often work with a lot of faculty in the university and hospital settings, and I'll meet with some of them and they'll say, well, Greg, do I really need a will? If I die here in New Jersey, presumably all of my assets just go to my spouse or to my spouse and my kids, right? So with that being said, we know that may not be the case. And Ryan, how would you respond to that?
Yeah, it's something I hear a lot. And the very short answer is that is not the right way to think about it. New Jersey is a very easy state in terms of dealing with an estate. We are lucky. New York, right next door, much more difficult. Pennsylvania, right next door, much more difficult. And Florida, where we have a lot of people leave, Two is also very difficult. We have a good situation here. Generally, if you are a married couple with children, you can assume that if something happens to you, everything will go to your spouse. And if something happens to the both of you, everything will go to your children in equal shares. But that misses, that simple construct misses a lot of things that can be involved in your estate plan. That is primarily just saying where the assets are going to go, not how they're going to get there. And so I'm just going to hit on a few points as to why it is still necessary to have an estate plan in place and to think of it in a more detailed way. The first number one thing is an estate plan is not just about your death. Your estate plan also protects you while you're living. So not having an estate plan means you are not taking care of yourself during your lifetime and making sure you have the proper legal protections in place. What I mean by that is making sure you have a power of attorney and a healthcare directive. A power of attorney appoints an agent on your behalf to handle financial decisions if you can't do so yourself. And your healthcare directive does the same thing for healthcare decisions. It appoints someone to make those decisions if you can't do so yourself. When I say you can't do so yourself, we're talking about some sort of disability, typically resulting in a lack of cognitive capacity. So you're no longer cognitively fit to make financial, legal, and healthcare decisions. If you don't have a power of attorney, if you don't have a healthcare directive, no one has legal authority to handle your own assets, your IRA, your 401k, your 403b, your 457, whatever it might be, your own insurance, etc. Anything that's titled in your name only, which even though you think all your assets are joint, there are numerous assets that can't be held jointly. Your spouse, your children cannot step in and deal with those assets on your behalf and preserve them, spend them as needed, keep insurances in force, etc., without legal authority. Without the power of attorney, without the healthcare directive, a court is now going to have to get involved to appoint someone to make decisions for you. We don't want that for a number of reasons. It's lengthy, it's expensive. It's literally 10 times the cost of putting in place a power of attorney. And finally, a court is now substituting their judgment for your own as to who should be managing your affairs. So that is number one. Anyone over the age of 18 should have a power of attorney and a healthcare directive, and frankly, a will, assuming they have some assets. Greg, do you have a question?
Oh, no, I just wanted to interject just real quickly. This may be a question for some of our listeners here, but when you said power of attorney, I was just thinking of digital assets. Mm-hmm. So we live in such a digital age now that we have all these online accounts. We have all these apps that we all use, Gmail, Facebook, you name it. And a problem could arise if they don't spell out these digital assets in a digital power of attorney or in some language in their documents. So with that being said, how would you approach this issue with those clients? Do you recommend a digital power of attorney or some type of language or agent so that they can step in? How would you handle that?
That's a great question. And it's something that's come up in the last 10 to 15 years primarily. Most of these tech companies do not have to abide by a power of attorney unless that power of attorney grants specific digital powers. So that's another thing. If you have accounts, if you have your own business where you use online assets like that, you're going to need a power of attorney to have someone be able to access that. As a small business owner, it's something my wife and I talk about, and we talk about succession planning, and God forbid something happened to me. Not only am I giving her a list of all of the online assets I have, but the power of attorney for her is drafted very broadly to allow her to access those. So that is something to consider as well in the year 2022. Just hitting these other bullet points at a high level again. If you don't do anything in New Jersey, again, you're probably that's typical nuclear family of a spouse and kids. Your assets are going to get where they need to go, but they're not going to prepare for a couple of things. If you have a family member who's disabled or special needs, it's probably not the case that you want them to inherit your assets outright, meaning a check written to their name. First and foremost, they may not be capable of managing those assets. Secondly, if they are receiving government benefits, which oftentimes they are, like Medicaid or Social Security insurance, those assets are means tested, which means typically you cannot have more than $2,000 in your own name and still receive your health insurance via Medicaid, supplemental income via Social Security. With the proper planning, the assets can be left to that individual, that special needs or disabled individual, in a way that allows them to both keep their government benefits, which are very, very important, and also to receive the inheritance and be able to access it and use it in a meaningful way. State law is not going to give you that. Unfortunately, I've seen situations where someone in a nursing home inherits $500,000 and essentially all of that money is going to the nursing home. We can avoid that via your will or via your estate plan. It's a very, very important thing. And it's not just for those people who have a known disability or special needs individual, but we can do it on a contingency basis in case someone that you love and you're going to leave assets to eventually develops a disability down the road and has that situation that we need to plan for. There's a couple other issues or areas where not putting an estate plan in place is going to diminish the value of their estate. It's going to result in a smaller inheritance for the individuals you love and you're trying to leave a legacy to. First of all, New Jersey has an inheritance tax. If you're in New York has an estate tax. Federally, there is an estate tax. And yes, it is a very, very high bar to meet the federal estate tax, but that's not the case in New York, and that's not the case with the New Jersey inheritance tax. So if you're not thinking about those things, there could be a haircut on the inheritance when you could have done some planning in advance and avoided that haircut or mitigated it to a substantial degree. Long-term care costs. We're going to talk about that in detail at the end, but your estate plan can plan for those things and protect assets from having to be spent on assisted living, home health aides, skilled nursing facilities. But that's not going to happen under New Jersey state law. When you don't have a will, your estate goes through something known as intestacy proceedings. So New Jersey law kicks in and picks an executor, picks who's getting your assets, and it imposes more costs and burdens on them. First of all, your heirs will almost certainly need an attorney to administer the estate at that point. That's an additional cost. I can speak to that personally. You will have to post a bond as a surety. Someone will have to post a bond as a surety to protect against the wasting of assets for your estate. That bond for a small estate can cost $2,000 a year. For a larger complex estate, it could be $5,000 or $10,000, and those larger estates are going to stay open for longer. And that premium, that $5,000 to $10,000 premium, hits every single year. So right off the bat, between legal fees and bond fees, you've now cost money when upfront planning would have avoided that. And then finally, when we talk about what I'm going to call a few times today a blended family, that is a second marriage where maybe both of the spouses that are in the second marriage bring children of their own to that marriage. We worry about disinheriting your own children. Really quickly, what I mean by that is if you assume that New Jersey law is going to kick in and make sure that your children are taken care of, even though maybe your assets are going to pass to your new spouse first, that may not be the case. If you, for example, just let New Jersey law play out, everything will likely go to your second spouse, and then that spouse will have the opportunity to draft his or her own will, and it is very possible that they could determine that maybe they just want to leave everything to their own children. And unfortunately, I've seen a number of situations where we have what I would call an accidental disinheritance of one of the spouses, the first spouse to pass away, their children. Overall, just looking at all of these, again, New Jersey law may effectuate the end goal of your assets going to your spouse or your children, but it will not do so in the most efficient way. It will not plan for long-term care costs. It will not plan for disability. And it's going to have some potential additional and substantial expenses involved. So my recommendation as a somewhat biased estate planning professional is that everyone at a minimum should have a will, a power of attorney, and a healthcare directive. It's going to protect you during your lifetime. And you could call it a love letter to your heirs because you're making sure that what you leave behind for them is left behind in an efficient way. It's going to avoid frustration. It's going to protect assets. And it's going to do so at one of the hardest, most difficult times in their lives because they're going to be grieving you. And we don't want to add any additional burden onto that situation. So now that you've agreed with me and put your estate plan in place, the next thing we want to avoid is failing to reconsider your estate plan, or failing to update it from time to time, or at least look at it from time to time. At a high level, I tell everyone when they ask this question after we sign the documents, when do I redo these? First and foremost, we design our documents to be durable, to stand the test of time, and to be flexible. That doesn't mean we can plan for everything. So we want to look at this every 5 to 10 years. For younger folks, I'd say every 5 years. Not that much should change. Maybe there's another child born, maybe there's a new account opened, and we'll deal with those things. As we near retirement and then advance past retirement, I say it's going to be more often because things can change more rapidly. Someone can pass away, we can have long-term care needs, etc. And all of these things can cause the need to adjust planning. And there are just a number of basic life events. Again, when we sit down and we sign estate planning documents, the conversation I have is I want you to tell me and keep in touch with me with everything you think might affect your estate plan, but specifically if you get divorced, if you get remarried. We want to make sure that in a divorce situation, we're probably going to want to remove your ex-spouse from your estate plan. If you get remarried, we're going to want to think about some blended family planning, making sure that your new spouse, if something happens to you, has access to your assets in a meaningful way to maintain a quality of life that they became accustomed to living with you, but also that we're putting mechanisms in place to make sure that if something happens to you, your new spouse can't either intentionally or unintentionally disinherit your children. Reaching retirement age, we're looking at the bottom bullet point. We're going to start thinking about planning for long-term care. We're also going to think about the fact that when you're retirement age, your children are probably older and they're probably ready to step in and be the fiduciaries in your estate plan, meaning they're probably going to be of appropriate age to serve as your executor, to serve as your power of attorney or your backup power of attorney. When you're younger, my current estate plan, my brother and my best friend are involved in it. When I'm older, we want to get them out of there. We want to have our family involved and keep it to that core family because that's really who has the most substantial interest in the plan. Greg, I see you're unmuted.
I just want to add to that, the point at the bottom of your screen, why change your estate plan and update it? So with tax law changes and changes in the law in general, sometimes I meet with faculty and they say, hey, Greg, we haven't added more kids to the family. I haven't gotten my estate planning documents updated in 20 or 25 years. So why that could be problematic, I want to provide one specific example, is HIPAA law. So the Health Insurance Portability and Accountability Act, which was passed back in 2003, summarizing it, is basically it precludes or prohibits medical providers from releasing medical information to unauthorized parties. So it's to protect someone's medical information. So for example, if I walk outside my office tomorrow, I get hit by a car, I'm now in the hospital and I'm incapacitated, and my spouse goes to the hospital and says, hey, here's my documents, what's going on with Greg? Well, the medical doctors, the providers, they may not release that information to my spouse, which could be very scary. So for those that are listening that maybe haven't had their documents updated in a while, for our listeners, if you haven't had your documents updated since prior to 2003, more than likely, the language may not be HIPAA compliant. So it's really important that you have them updated every so often.
Yeah, and that's a great point. But back then, you look at older documents, they don't have HIPAA releases in them, especially the power of attorney and the healthcare directive. Every document I draft now has a HIPAA release, so we make sure people, loved ones, can get informed about their loved ones' medical situations and help them make the right decisions. And tax laws, you mentioned tax laws there. I bet for anyone who has a will that was signed anywhere between 2000 and let's call it 2016, there's almost certainly some clunky trust mechanisms involved to avoid New Jersey estate taxation. Probably when the first spouse passes away, a substantial portion of the inheritance is going to go into trust for the second spouse. And that trust is going to be somewhat restrictive in terms of how the surviving spouse can use the money in it. It's done that way to avoid the previously punitive New Jersey inheritance tax that kicked in anywhere over $675,000 or later $2 million. That tax is gone. And I see a lot of estate plans that still have these forced trust mechanisms in it that is going to make the estate more complicated, more cumbersome, and more expensive to administer, and then result in assets being somewhat tied up in a trust. I don't want to overstate that. These trusts can be very flexible, but it's still something that is essentially not needed and creates complication that is unnecessary. Reasons we talked about kind of the life events of when to look for a new estate or to revisit your estate plan. But again, going more into the reasons, we talked about tax laws, we talked about HIPAA, reconsidering probate avoidance. Probate is the process of using a will and getting it admitted by the court and getting through someone's estate using the will to deal with their assets and to take title to those assets. It's an easy process in New Jersey relative to other states, but it's still lengthy. It still involves a court, and it still involves some additional fees and probably some lawyer fees as well. We can avoid all of that for the most part by putting beneficiary designations on your life insurance, your 403B, even your checking account can have a transfer on death as designation. What that does is that when you pass away, someone pretty much walks into the bank with a death certificate and fills out a few forms, and they now take possession of your assets. We like that. The probate avoidance is going to be that love letter. It's going to make sure that while your heirs are grieving you, they're not also fighting banks and courts and financial institutions to get a hold of assets, to pay debts, maybe to keep a mortgage current, etc. So we look to see, have you opened new accounts? Have you purchased new life insurance? Do we need to change or update beneficiaries? That's something to reconsider on a regular basis. And then again, we talked about retirement age. We really want to think about planning for long-term care for folks who don't have long-term care insurance, or maybe they do, but they want to complement it with some additional asset protection planning, which we'll get to in the end, but with the goal being to avoid spending more on long-term care than necessary. There are a lot of reasons to update an estate plan. Not all of them we can go into here, but it is something, again, I recommend looking at every 5 to 10 years. If you have an estate plan and one of these events has happened recently or even not so recently, it's worth revisiting it with an attorney or just going over it to see if any changes need to be made, or talking to Greg about it and then seeing what he has to say. And just the last point there, banks hate old powers of attorney. I see people with powers of attorney that are just 10 years old, and the bank is requiring them to jump through additional hoops, sign affidavits, get documents notarized just to use the power of attorney. So having a new one every once in a while, it's frustrating that we even have to do that, because the law very clearly says that a power of attorney remains effective regardless of the passage of time. It's nice to have a new one. So jumping in, next point, we know now why to have an estate plan, when to update an estate plan. Should you use LegalZoom to do that estate plan? I will admit I am inherently biased here. So you are going to get the opinion of an attorney saying, well, you should use an attorney. But LegalZoom has its place. If you are in your 20s, you don't have kids, you have minimal assets, use LegalZoom. You'll be happy with the price, as you can see from that smiley face, and you'll probably get what you need because we're not overly worried about a lot of complexities there. The fees, again, very good. Compared to an attorney, oftentimes much better. An attorney, you can be very happy with the fee, if you see the happy face, or you can be very disappointed because there are attorneys out there that will charge you a very hefty sum to do an estate plan. My view personally is that an estate plan should be done at a very affordable and palatable access point. So you can be very happy with an attorney. You're probably never going to match the LegalZoom fees, which I think, Greg, you might know better than I, but I have to imagine we're talking low hundreds of dollars, where if you're going to go with an estate planning attorney, I think at a minimum, you're probably going to be in for $1,500 as a married couple, probably more than that, but that's probably the lowest entry point.
Yeah, that sounds about reasonable.
Thank you. And once we move beyond the fees, if you believe my faces here, the smiley faces versus the happy faces, LegalZoom starts to become a lot less attractive. We talked earlier about planning for disability, planning for special needs individuals. LegalZoom's not going to do that for you, especially not just with a simple will, which an attorney can do with a simple will. They're also not going to tell you all the ins and outs of how that plan has to work. An attorney that handles estate planning on a regular basis is going to know the levers to pull to make sure we're protecting assets for those special needs or disabled individuals in your life, or having a contingency plan in place in case someone who is fine now becomes disabled down the road and you hadn't updated your estate plan to deal with that. Probate avoidance, again, we talked about the value of having your estate not go through probate, especially outside of New Jersey, but also within New Jersey. LegalZoom doesn't guide you on that. It doesn't set that up for you. It doesn't tell you how to title your beneficiaries. When you work with an estate planning attorney who really does true estate planning, they'll handle all that for you. They'll fill out the forms, they'll submit the forms for anything that you have to do yourself, which is required sometimes. They will coach you on how to do that. We talked about estate tax planning. Capital gains taxes are also an important consideration. Inheritance tax in New Jersey is an important consideration. LegalZoom does not coach you on those things. It does not set up disclaimer trusts that you might need, which, again, another conversation for another day there. But it doesn't do any of that. An attorney is going to handle those things. It's going to advise you on the advantages of dying with assets in your name to get a step up in capital gains in taxable basis and avoid capital gains tax. It's going to teach you how to gift assets if you're over tax limits in New York, or if you have an inheritance tax issue in New Jersey. It's just a major advantage. Again, someone in their 20s probably doesn't have that issue. Once kids come into play, once life insurance and houses come into play, we're going to start worrying about that stuff. And then finally, liability protection. What I really mean here is there a pocket? Is there a body to sue in terms of if something goes wrong? LegalZoom will have a large waiver and disclaimer included as part of your purchasing of a plan from them. That waiver and disclaimer will essentially provide that they are going to give you template documents, and if something goes wrong with those documents, so be it. They're not going to be liable for that. Attorneys don't get to do that, and we also have E&O, errors and omissions insurance, or malpractice insurance, you could call it, that backs us up. So unfortunately for me, but fortunately for the client, there is a deep pocket to sue in those instances. So if something does go wrong, you have some recourse there. And it's not just you sitting out there and getting burned, unfortunately. So from my, again, admittedly biased view, I think LegalZoom has its place. I think it's a narrow place when it comes to estate planning, but it is a resource that people can use with very, very simple situations. Beyond that, it really is best to work with an attorney. And I would say to work with an attorney who does estate planning. There are plenty of real estate attorneys out there who are very good at what they do, and they have an old will and a power of attorney in their desk drawer. They pull it out and they dust it off and they change the names. I probably wouldn't go with those guys, but focus instead on going to someone who their practice is based around estate planning. So next, the pitfall we mentioned is not using a trust when it's appropriate to do so. And I'm going to go a little quickly here because I know we are running short on time, but generally what I want you to understand is that first, there are two types of trusts, and second, to identify some of the issues that make trusts relevant and necessary, or at least advisable for your estate plan, so that if you have these issues, you think about them and you consider maybe doing something to address them. The two types of trusts are revocable, and then the opposite of that trust, which is irrevocable. A revocable trust means you put assets into this trust, this bucket that can hold assets, and you can take those out, you can put them back in, you can swap assets, you can use the assets in the trust. They're yours. They're just the legal title. Instead of being Ryan Brodlin, it's now the Ryan Brodlin Revocable or Living Trust that holds them. The only difference, again, is the title. We use revocable trust primarily for three reasons in New Jersey. The first is when you maybe are getting up in age and you're worried about your capacity. Maybe you have a diagnosis of early onset dementia, or Parkinson's, Alzheimer's, whatever, and you want to make it as easy as possible for the transition of managing your financial affairs over to your family members. We talked about powers of attorney earlier. They are excellent mechanisms, but I already gave you one example of how they can be tricky to use, which is when they're older. But banks love to pick on powers of attorney and make it a harder process for the agent, the person who is the power of attorney, to access assets, make withdrawals, pay bills, etc. When assets are held in a trust, you can simply name a co-trustee or a backup trustee. who steps in when you no longer have capacity. And now they actually have legal title to the assets. The assets can still only be used for your benefit, but they are treated as the owner for all intents and purposes when we think about accessing those assets and paying bills and making withdrawals. So that's one reason people use it. I'd say that's less frequent. The next is the one where we really recommend a revocable trust, which is when you have a house in New Jersey that you own, and maybe you have a house out in the Poconos or New York or down in Florida. If that's the case, you actually have to open probate. That means get appointed as executor. When you pass away, your executor has to get appointed in New Jersey, and then they have to go down to Florida and probably have to go down in person and get appointed in Florida, which means we now have 2 probate proceedings, we have 2 attorneys, we have maybe not twice the cost, but additional cost and additional hassle. Anything inside of a revocable trust avoids probate. It's just like having a beneficiary designation on an asset. And what it does is avoids the need to open probate in New Jersey and Florida. Instead, the assets pass via the terms of the trust, and there is no court involvement. It's also a good mechanism for privacy. If you're someone who doesn't want anyone to know about your affairs after you pass, a revocable trust is a private proceeding, whereas going through a will is public, and it is public record and accessible by anyone, essentially.
Ryan, if I could just interject for a quick second. I know with revocable trusts, from a financial planning perspective, isn't a revocable trust really just like a will substitute? And where I'm going with this is, I know there's a lot of talk in New Jersey about, hey, my friend has a trust, my neighbor has a trust, I should have a trust, right? It's what wealthy people do. But when it comes to the probate process here in New Jersey, correct me if I'm wrong, but isn't it pretty straightforward, right? Like I just need a will, a death certificate, and a filing fee. And in some cases, would you even argue that a revocable trust could be maybe unnecessary?
Yeah, you will find a lot of attorneys that push revocable trusts. My personal view is that's likely because they can get a higher fee because it's more complex. And there's a big push for probate avoidance, and it does provide value even in New Jersey. That being said, you're right. In New Jersey, if someone passes away, 10 days later, you are allowed to go to the court with a copy, with the original will, a death certificate, and probably $175 filing fee. And typically within 7 to 10 business days, you are now executor and can go out and get the assets. So if probate avoidance is the only goal, I don't advise it, again, unless you hit that second bullet point there, which is owning real property in 2 states, because now you're opening probate in 2 states. Chances are that state will not be as easy on probate as New Jersey. New York, for example, makes you file a formal complaint. You actually have to serve formal process on the individuals involved, meaning a process server, someone who walks around and says, "Sir, you've been sued." They don't say that, but they will knock on, you have to go send them to someone's address, and they have to personally hand over papers to that individual. And it's a much more difficult process. New Jersey, just for comparison's sake, all you have to do is send the person a letter and say, "Hey, I'm the executor. If you want a copy of the will, let me know." So for probate avoidance only, I don't recommend it.
We can certainly, and I'm sure the viewers agree, we appreciate your honesty. And, in certain situations, it can be appropriate, but there are some others where you may not need it. So that's good to hear.
If you're in New York, I absolutely recommend it. I personally avoid New York probate as much as I possibly can because it's expensive, it's time consuming, and it's much more difficult. So if there's anyone here whose primary residence is New York, I would consider it. Finally, I mentioned that blended family planning. I won't go into all the mechanics here because it probably would take us another half an hour. But we use revocable trusts when we have second marriages very often to again, make sure the surviving spouse, when the first spouse passes, has access to funds and to the first spouse's funds in a way that allows them to maintain quality of life while also preserving those assets to make sure they get passed on to that person's children and those children don't get disinherited. An irrevocable trust is the opposite of a revocable trust. You are taking assets and you are forever giving them away. You are saying, I'm putting these assets in trust. They are for the benefit of my children, and I can never take it back. I cannot revoke this trust. To be very clear, when we do that sort of planning, we are still maintaining levels of access to those assets in sensible ways that comply with the appropriate laws, but we're using them for two reasons in New Jersey, at least. The first is long-term care planning. We'll talk about this more, but Medicaid, again, has asset limits. Medicaid pays for long-term care. If you are above those asset limits, Medicaid does not pay for long-term care. Your own funds do. We use irrevocable trusts to have those funds no longer count towards the asset limits, so they don't have to be spent, and Medicaid will kick in. Second, New Jersey has an inheritance tax. It applies if you are leaving assets to what are known as Class C or Class D beneficiaries. That is going to be brothers, sisters, friends, cousins, nieces, nephews, aunts, uncles, etc. Anyone who is not a parent, child, grandchild, spouse, great-grandchild, think, yourself, draw a line up or a line down, or your spouse. If it's not that person, they pay between 11 and 16% tax on your inheritance. If you give away assets more than 3 years prior to your passing, that inheritance tax does not apply. So sometimes what we do is we put them into an irrevocable trust, again, so we can maintain the level of access to those assets, while also making sure we mitigate or maybe even avoid the inheritance tax entirely. But really, the 99% of times that I'm using an irrevocable trust is for long-term care planning. So let's get into that. So first, really quick, a primer on long-term care. When we talk about long-term care, we're talking about home health aides, assisted living, and nursing homes. Things that most of us hope to avoid, but things that 50% of individuals or more that turn 65, so if you make it to 65, there's a 50% or higher chance that you will need a long-term care provider at some point. Long-term care is very expensive. The average cost you see here, I'm not trying to read from the slides, but it's $4,000 to $12,000 a month. There's a number of studies you can see on that. The one that I often typically look at is Genworth, because they are a long-term care insurer and they really study this stuff. And I'll tell you, those numbers are low. $4,000 a month is typically going to be home health aides at home, and it's going to be someone who needs a very low level of care. $12,000 a month is probably a nursing home, and those costs can be substantially higher as well. When we get to the Bergen County, those areas, even some of Essex County, we can be at 13, 14, 15. God forbid you're in a nursing home in Manhattan, we can get into $20,000 a month, no problem. Social Security of $2,500 a month is not going to cover that. So it's up to your own assets, because despite what some might believe, Medicare, which is the insurance we all get when we turn 65, does not cover long-term care. It will not provide home health aides. It certainly will not provide assisted living, and it will cover only a rehabilitation stay at a nursing home. That's going to be 0 to 100 days. The first 20 days are covered in full. The next 80 days have a substantial copay. I believe it is currently $170 a day. Most people I deal with maybe get 20 days, and then Medicare kicks them off of coverage because they're not improving enough. At that point, the number one payer in the United States for long-term care costs is yourself. It is privately paying. Over 50% of long-term care costs come out of the individual's own pockets. So we have to think about that, because A, it can deplete all of your own assets, so you have nothing left in your lifetime, and B, if this is important to you, it could deplete the legacy you hope to leave behind. You've worked hard your whole life. If you have kids, I imagine you'd like to leave something behind for them, and too often I see people who leave nothing behind, and maybe are even a financial burden on their children because there's no long-term care planning. When we think about long-term care planning, there are two big tools we use. The first, and I think the most effective, is long-term care insurance. I'm not an insurance salesman. I have no vested stake in this. I can tell you when I hit my 40s or 50s, which is very soon, unfortunately, I will probably be looking into long-term care insurance. At a minimum, a life insurance product that has some long-term care coverage in it. It's a phenomenal portfolio asset protection tool. Long and short of it, if you need assistance with daily living, feeding yourself, walking around, getting up and down, getting dressed, showering, etc., Long-term care insurance will provide a daily payment to offset that cost, usually for either a period of time, like 5 years, or for a dollar amount. So you might get $250 a day for up to $300,000 over your lifetime. It's an incredible tool that if you are, and Greg, I'll let Greg really weigh in on this, but if you're in the right age range and your budget can support it, I strongly recommend having it as part of your portfolio.
Just to add to that, Ryan, long-term care insurance is an option, but it may not be for everyone. And self-funding may be the best option for you at the end of the day. But if you're going to look into long-term care insurance, if you like things when they're on sale, you buy when you're young and you're healthy. So with that being said, the sweet spot is really the earlier you get it, the cheaper it can be. So for example, if someone's 60 years old, from a pricing perspective, if it's $250 a month for a policy, if you wait until 65 to purchase that same policy, the price nearly doubles. So it can become very cost prohibitive, and you really need to sit with the financial planner to go through an analysis to see, hey, is it a viable option? If not, we may have to come up with some alternatives like health savings accounts or even pros and cons, but it's really important that you look into it. And if you can afford long-term care insurance, it can be a viable option.
Yeah. And if you have long-term care insurance already and you're thinking about getting rid of it, talk to Greg or whomever first, because when people come to me and say that, my typical advice is do not let go of that policy no matter what. It is what's going to carry you through tough times. If you don't have long-term care insurance because it wasn't affordable or you didn't qualify or you waited too long, whatever the reason, then we're looking at what's known as a Medicaid Asset Protection Trust. That is an irrevocable trust that I mentioned. The long and short of it, we're not going to be able to get into the mechanics of that kind of trust. But what it does is it takes assets and takes them out of your name. So we are actually gifting assets to your family members via this trust. Anything in the trust no longer counts as being owned by you. When we look at long-term care costs, Medicaid is the program that helps defer those costs or pay for them substantially in New Jersey. And Medicaid does not kick in until you have under $2,000 in your name. So if you're someone who's done well and you've saved and you own your home and you've got some qualified, 403B accounts, you've got an investment account, Medicaid will not cover your care until those accounts are spent down to $2,000. And if you move out of your house because you need to go to a nursing home or an assisted living facility, the state will require that you sell that house and then spend the funds from that sale on your long-term care. We can reverse that result, or at least mitigate that result almost entirely by putting assets into an asset protection trust. We have to wait 5 years. It's a 5-year plan because Medicaid looks at transfers 5 years prior to your application. But what happens is we put the money in the trust. We wait 5 years. If a long-term care need comes up, now we can apply for Medicaid and legitimately be under the $2,000 asset limit while not having had to spend all of that money and instead just protecting all of that money. The trust, in broad strokes, is designed to allow you to access your money via your children. They have the access to get money out of the trust and to give it back to you if needed. The trust, however, does say that you have no right to take the money out. So we have to have, as the term would imply, a great deal of trust in our children to make that plan work. We don't do that plan if we worry that the children will take the money and use it on themselves. And it really is a family discussion when we're doing that planning. But it is very, very valuable planning. And just to paint the picture of the flip side, if we have someone who has a $500,000 house and $500,000 in an investment account, and they end up needing nursing home care, they will not get any help for that care until all of those assets are spent down. Whereas if we have the trust, some of those assets will certainly be exposed because there's always going to be some level of private pay required, whether it be a few months or a year or whatever it is. When that period's over, we don't touch the trust assets, and we've now got maybe $1 million, maybe high six figures sitting in a trust, protected, available, and a guaranteed inheritance for your children. In addition to that, we don't ever have to worry about our own long-term care costs being a burden on our children financially because now they have to come out of pocket since we've exhausted all of our funds. So it is the number one thing I see people miss in their estate plans. I'm in the car a lot. One of the things I love to do is listen to financial and retirement-based podcasts. And I can tell you, even those guys who are thinking about every facet of taxes and IRA planning and investment returns, they don't talk about this because a lot of people just don't know to think about it. It's still a relatively new area of law, but it's something that I'd say for anyone late 60s, early 70s and up, they should absolutely be considering as part of their estate planning documents. And again, late 40s, early 50s should be considering as part of their insurance portfolio. With that, I'll turn it back to Greg. But hopefully you've taken away something valuable. Again, any detailed questions or personal situations that you don't want to talk about here, please feel free. My time is what I have to offer. It's yours, and I'd be happy to go over anything I can with you just to see, again, if you are in the right spot and you've dotted all the I's and crossed all the T's. I hope that's the case because, again, I love sharing that news with folks. So back to you, Greg.
Awesome. Thanks again, Ryan. And I think now would be a good time just to answer some of these questions that we have. So if you look at your Q&A box, if you have any questions, please type them in. It seems like we have quite a few already. And Ryan, I'll shoot you the, excuse me, the first question here. What do you mean by updated? Is this an addendum?
Yeah, so updating your will or your estate plan, most times you can do an addendum. What's for your will is called codicil, which is either revising or adding provisions or removing provisions from your will. Typically, when I do it, we're just going to draft a new will because, quite frankly, it's easier for everyone. And if we need to use the will, if we have an amendment or a codicil, we now have to hope that the person probating the will, the person submitting it to the court, also has the codicil and not just the will, because if they only have one, the other one will not get enforced. So I like to type a new will. I like to tear up the old will. From a time, efficiency, and cost perspective, it's no different. It just results in a cleaner estate planning package at the end. The same goes for powers of attorney and healthcare directives. It's just simply cleaner to draft new ones. And again, it doesn't affect the price point or the process in terms of length or difficulty for clients. So that's my typical route, is to just draft new documents. But again, oftentimes updating an estate plan does not mean even doing any new documents. It might just mean looking at it to make sure everything's okay and maybe updating the beneficiaries because you opened a new investment account and you didn't think about putting beneficiaries on it. And really, it can be a very low-touch environment.
No, that's a great response, Ryan. And I think that answered another question I see here. Do you need to revisit wills and directives with the original attorney? Ryan just answered that. Basically, the answer is no. So you can have it done with a brand new attorney. They can start you from scratch. You do not have to use your old attorney.
Yeah, if you're my client, I prefer you come back to me. But oftentimes, maybe you did your wills 20 or 30 years ago. That attorney might not be practicing anymore. So at that point, you want to find someone new. But you can pretty much go to anyone you want. The most important thing is A, finding someone who specializes in estate planning, and B, making sure they know your state law. If you moved from New York to New Jersey, even, you want to make sure you now have a New Jersey attorney rather than a New York attorney.
That's a great point. Ryan, what is a disclaimer trust?
Yeah, I definitely glossed over that. So for folks who did wills in, let's just call it 2000, your will probably says that everything up to the estate tax limit, which in 2000, I was in college, I wasn't practicing estate planning yet, but I'm going to say it was around $675,000 because New Jersey was there for a long time. If you had over $675,000 that you left behind, you now have a tax issue. So what would happen is that your spouse would get a full $675,000 and then have the option to disclaim or waive the remainder of the inheritance. And that remainder went into what's known as a disclaimer or a bypass or an A/B trust. Those trusts, the beneficiary is still the surviving spouse. So the surviving spouse gets $675,000 in their own name, and everything else goes into this trust that they are the beneficiary of, and usually even the trustee. So they have the ability to spend money from that trust account, but that ability has to be tied to ascertainable standards. which means they can only spend trust funds on their health, education, maintenance, and support. Those are broad categories, but they are still limiting, and it can cause tax issues if you do not follow them. So those are in a lot of wills that were drafted in New Jersey prior to 2018, I think, or 2017. Chris Christie revoked the estate tax. So the legislature, with his signature, revoked the estate tax. And so those wills now, some of them are disclaimer trusts, so we don't really need to update them, but some of them are forced trusts, and they automatically put money into that trust. And those are the ones we want to look at and probably get rid of, or at least soften the mechanism that puts it into a trust so that we don't have to use it. We just have the option to use it. God forbid the estate tax comes back in New Jersey. Greg, I think the next question is best answered on your end.
I will be happy to take that one. So is there a time difference for men versus women regarding when to buy long-term care, or does it have to do with your current health? So the short answer is, I would say from a underwriting perspective, when the insurance companies look for someone that applies for long-term care, men versus women, women naturally live longer than men and are more prone to using the long-term care policy. So naturally, it's going to be more expensive for a woman purchasing a policy versus a male. So in that case, I would implore you to not only do it while you're young and healthy, but if you're a woman, you have even more of an incentive because you'll be priced out disproportionately versus a male who, statistically speaking, the underwriters will price a little bit cheaper compared to a female. And once again, buy it while you're young and you're healthy.
Yeah, absolutely. And it's the exact opposite result of life insurance. Life insurance, the men get hit much harder on the premiums because we die earlier.
Yes, we do.
I'm happy to take this next question, Greg, which is, I mentioned that trust should be used in a will if a beneficiary is disabled. But what if the beneficiary becomes disabled after the will is drafted and it's too late to amend that will? Is it too late to do a trust for that disabled person? The best answer to this question is we build in those contingencies. So we have what are known as forced trusts and contingent trusts. So any will I draft where I know that someone is disabled already or has a special need, we are going to most likely force their inheritance into a supplemental needs trust. That is the type of trust that allows them to A, have the benefit of those assets, and B, continue to receive Medicaid, SSI, et cetera. SSI being Social Security insurance. For any other will I draft, I put in what's known as a contingent supplemental needs trust, which says that if someone becomes disabled after the date of this will, my executor has the option of leaving their inheritance into a supplemental needs trust. It's not something that any old attorney will do with a will. It's something that typically someone who deals with special needs planning or elder care planning, elder law planning will do, because it's just something we deal with all the time. We see those situations where an inheritance is left to someone living in a nursing home who was already receiving Medicaid, and Medicaid was covering the full cost or the most of the cost of that nursing home. And now they've got $250,000 or $500,000 in their name, and it all basically gets paid to the nursing home instead of continuing through the bloodline and continuing to benefit that family. To be clear, there are much worse results. It's not the worst thing, but I imagine most people, if we really played out those different scenarios for them, would likely want that to not be the case. So we always have that contingency planning in the will if we do it right.
So I think that is all the questions for this evening. And just want to say thank you again, Ryan. It was really insightful. I think you gave our viewers and our listeners a lot of some really good tips so that they can better plan around their estate plan. And for those of you that are wondering, well, hey, is my estate plan up to date? If you're concerned about it, feel free to reach out to Ryan. Maybe you can use him as a resource. And be sure to register for our next New Jersey Faculty Wealth webinar, which is coming up here on May 4th, where we'll be discussing Roths and how to potentially lower your retirement tax bill. So once again, thanks again, Ryan. And thanks again to our viewers and our listeners. Have a wonderful evening. Take care. See everyone soon.
Take care.